Hello, everybody. Hello, Princess Ava.
All right, the next case is Capital One versus Chloe Gadberry. It's file 24-39986-GC.
Good afternoon, Your Honor. Thomas Duquette, P829588 on behalf of the plaintiff.
We have Ms. Gadberry with us.
Yes, I'm here, Your Honor.
All right, thank you very much. I appreciate that. I believe this is the date and time set for a motion for summary disposition. I've received and reviewed that motion from the plaintiffs. I've also received and reviewed a letter from Ms. Gadberry talking about experiencing significant financial hardship. So I'm going to give each party an opportunity to briefly state why they believe that their position should be granted, starting with the plaintiffs. Counsel, go ahead.
Yeah, thank you, Your Honor. This is a straightforward collection action, not an unpaid credit card account. Attached to the motion as Exhibit A is 68 pages of account statements. They show that the card was utilized to make purchases. They show that payments were made on the card. There was never any objection to these statements on a monthly basis. Those charges and subsequent payments ratify the card agreement, which is attached to Exhibit B. There's also an affidavit attached as Exhibit C, which attests to the amount that my client's seeking as damages. It's $4,866.28. There's also associated court costs. We would ask the court to grant judgment for the damages and the court costs.
All right, Ms. Gadberry, this is your opportunity to tell me why you think that I should grant your position. Go ahead.
Well, this entire time I've been trying to, since mediation, do some sort of settlement with Capital One. But during mediation, Jeff Bears quickly turned it because I had that other settlement and I was confused why there was a suit and a settlement at the same time. And instead of explaining it to me, he just told the mediator that we weren't doing anything that day and it was done. And then on May 15th, I emailed Thomas for requesting settlement and I never got a response, just like every other act of communication that I've had with them.
Well, but he's attached, and all that may be true, but he's now attached to, counsel's now attached to the document entitled Motion for Summary Disposition. A lot of those documents that I assume that you were looking for. So based on that information, why should I not grant what they're asking for?
That's not my goal. I'm asking for the settlement that I requested to be granted.
What is it that you want to pay to them each month?
I can afford $94 a month. The settlement that I sent to Thomas, let me pull it up. I requested to pay 45% of the total judgment at $2,255.84 at $94 a month over 24 months.
Counsel, do you have a response to that?
Yeah, my client would decline that offer. They're not going to accept a reduced sum over an extended period of time. I'd be happy to set up a payment arrangement on the full balance. Could do $150 a month as the minimum amount that I could accept on a monthly basis.
All right, here's what I'm going to tell both parties when it gets to this kind of a situation. It appears to me under the motion for summary disposition that plaintiffs are entitled to a judgment. The defendant really isn't objecting to that. She just wants to have a lesser amount to pay on an installment payment plan. And so I'm going to grant the judgment for what it is asked for at the moment. I'm going to direct the parties to try to negotiate between themselves. And ma'am, if you're unable to do that, then you need to file a specific motion for installment payments. And if they don't agree to that, I'll have a hearing in front of me in the future about whether or not that's an appropriate payment plan and an appropriate amount to pay. But the only thing that's actually in front of me today is whether or not to grant the judgment for the dollar amount that they are asking for. There's a 21-day appeal period for that. And then they can take enforcement action after that, and you can object to whatever that enforcement action is. But if I were you, I'd be filing a motion for a installment payment plan relatively quickly, although I can't advise you what to do for legal purposes. So, counsel, do you have a proposed judgment that you can send to the court for the amount that you've requested in your motion for summary disposition?
There should be a proposed order included with our filings.
All right, I do see one at the back. In the amount of damages of $48.66.28, court costs of $146.70 for a total of $5,012.98. That does appear to be appropriate. So I'm going to sign that. All right, that'll take care of today's. And then, ma'am, as to the installment payments, do you understand what you need to do in the future?
Yes.
All right, that's all for today then. Thank you very much.
Thank you, Your Honor.
All right, the next case is LVNV Funding versus Jonathan Watson. It's file 25-40155-GC.
Thank you, Judge. I think we have both sides. Judge, may it please court Richard Grusin for the plaintiff, my bar number 35222.
All right.
Good afternoon, Judge. Elliot Blumberg on behalf of Mr. Watson, who's appearing via Zoom from my office.
All right, thank you. I've read the complaint and the answer. It appears that the defense is identity fraud and it weren't me. Where do you want to go from here, counsel?
Well, Judge, from our perspective is we believe that the perpetrator of the identity fraud has been arrested in the Commonwealth of Kentucky. We're just waiting to get some confirmation of that.
Judge, may it please court, I find that interesting because needless to say, when you get on the horse of a collection case, you never know where the horse is going to leave you. So anyways, I'll send an email to brother counsel after the close of the hearing. And if I could gently ask now, as I will in my email, if brother counsel can give me that information, I think that would be very, very, very illuminative to my client. And I think in my heart of hearts that we can dispose of this case very quickly and amicably. With that, I rest.
How about if I set this for a status conference in 30 days and ask the parties to exchange information? Plaintiff's counsel, if you get sufficient information from Mr. Blumberg, please simply send me a dismissal and we'll be done with the case at that point. If not, we can come back and do discovery and whatever else we need to do at that point. Is that sufficient for everybody's needs?
It is. And counsel, I would just ask, what I have received is a kind of a bare bones complaint. I don't see any of the actual documentation associated with the credit card. If you would, maybe we can exchange documents. That would be great.
I think that's a great idea, brother counsel. And brother counsel, if I can tell the judge, Your Honor, based on the fact that we have now the state of Kentucky overshadowing this case now on the facts, rather than the 30 days, Judge, can I gently ask for 45?
Certainly.
You know, for the status conference.
Yeah, if the information is accurate, it would likely result in a dismissal of the case, so I can be a little more lenient in those kinds of things. So we'll set it out 45 days. Hopefully it gets resolved in that period of time. That's all for today then. Thank you very much.
Judge, I just would ask counsel.
That'd be great. And counsel,
are you actually under
brother
the
counsel? I'll call you after the hearing, brother counsel. I have another one before the judge.
Okay, never mind about the bridge. All right, thanks.
All right.
And good morning. Are you William Lewis Severinghouse?
Yes, sir.
I have two files here. The first file is file 251252FY. And on this case, you were charged in a felony complaint that was issued by the Allegheny County Prosecutor's Office on charges of resisting or obstructing of a police officer. There was a misdemeanor charge for trespassing on railroad tracks. They also indicated you were a second habitual felon with a prior conviction for attempted resisting or obstructing of a police officer out of this court from approximately 2 years ago. On that case, the magistrate released you on a PR bond on April 15th of this year. At that time, you were appointed an attorney at public expense through the Public Defender's Office. Matter came up, it looks like, for several several probable cause conferences. And the last one was set for last Thursday, June 26th. At that time, the indication from the prosecutor's office and your attorney was that you failed to appear and a bench warrant was issued at that time. On that case, bail is currently set at $5,000 cash or surety, and that is not being set on the charge. That's being set for your failure to appear after having been given a PR bond. On file 252235FY, you're here today for arraignment on a new felony complaint that was issued by the Allegheny County Prosecutor's Office. It looks like this was issued the following day on June 27th. Another charge for resisting or obstructing of a police officer. Mr. McCain, please.
Yes, Your Honor. This is Jefferson McCain appearing on behalf of Mr. Severinghouse for the limited purposes of arraignment and for his conditions of bond on his other case. We have reviewed the charging complaint and waived its formal reading. On that case, we would he does qualify for a court-appointed attorney, and we would request that matter be set for a probable cause conference and preliminary examination. We would request in this case that Mr. Severinghouse's bond remain at a $1,500 PR bond, and we would request that Mr. Severinghouse's bond not be revoked. Mr. Severinghouse missed court not because he was intentionally trying to avoid the court, but rather because he suffered a number of technical difficulties that prevented him from attending court on that day. Mr. Severinghouse is dedicated to addressing this case, and he is committed to attending court in the future. Thank you, Your Honor.
On file 252235FY. Again, this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set that for you within 2 weeks. Your probable cause conference is set for next Thursday, July 10th, and that will be at 1 p.m. in District Courtroom B. Preliminary examination itself is the following Wednesday, July 16th at 9 a.m., and that will be in this courtroom, District Courtroom A. On this case, at warrant authorization, bail was set at $1,500 personal recognizance. And I think what I will do is leave this one as is, so bail will be continued at $1,500 personal recognizance. Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. It will most likely be the same attorney you have for the charge that you failed to appear on. In any event, an attorney from the Public Defender's Office will contact you to discuss this case with you before the date and time of your pretrial conference. On file 251252FY, again, matter was set for a probable cause conference last Thursday afternoon. You had no obligation to come to court. You had no obligation to even appear on a video. All you had to do was to get a hold of your attorney somehow and let your attorney know that you were available so they could consult with you. You did nothing, and your attorney indicates they had no contact with you. And at that point, a request was made for a bench warrant. A bench warrant was issued, and according to the affidavit on the new case, the following day, on June 27th, the Allegheny County Sheriff's Department tried to arrest you on that bench warrant. They indicate that they called your name and you looked right at them and were told that you had a bench warrant out for his arrest, and then you took off running. The officers had to chase you. They had to set up a perimeter with other officers. They saw you running, lost you, eventually found you hiding in a camper. The owner of the camper gave them consent to go inside the camper. They located you hiding in the back under a pile of dirty clothes. This does not sound like someone who had technical issues. It sounds like someone who was avoiding a warrant. I am going to leave bail on the first file at $5,000 cash or surety. And what I'm going to do is to see, and this is just to see, if they can add this to our probable cause docket for Thursday. They may be able to do that. And on this case, that would mean your attorney would be talking to you potentially on Thursday. In any event, I don't do the scheduling, but I'll just make a request since you're currently lodged on this to get this set as soon as possible. So it'll potentially be 1 o'clock on Thursday afternoon. Your attorney on this case will be getting a hold of you to talk to you before that as well. So again, we'll do the best we can to get this set for you as soon as possible. Good luck to you, sir. Thank you, Mr. McCain.
Thank you, Your Honor.
Be safe, be well, sleep sweet, and much love.